Next, President Kim Min-seo, the President of the Korean Society of International Law, will present opening remarks. Please join me in welcoming President Kim to the stage with a big round of applause.
Your Excellencies, distinguished colleagues and guests, I'm honored to welcome you to the 9th International Conference on the Law of the Sea, organized by the Ministry of Foreign Affairs of the Republic of Korea, the International Tribunal for the Law of the Sea, and the Korean Society of International Law. This year marks the 30th anniversary of the United Nations Convention on the Law of the Sea. After 10 years of negotiations, the convention was adopted in 1982 and came into force in 1994, after being ratified by the 60th country in 1993. We now look back on 30 years since its entry into force. The signing of this convention in 1982 was an important moment in history, following the League of Nations and 3 major international conferences organized by the United Nations. It is meaningful to reflect on its history this year, as the convention has played a key role in shaping the law of the sea over the last 3 decades. At this conference, we will focus on important topics such as territorial seas, exclusive economic zones, continental shelves, marine environmental protection, and dispute resolution under the convention. We will not cover the deep seabed in detail today, as it is better suited for discussion at another time. This conference offers a valuable opportunity to exchange experiences and knowledge from the past 30 years, with presentations and discussions led by leading experts in these areas. The law of the sea is not only a critical part of international law, but it also offers clear examples of how international law works in practice. For instance, the relationship between treaties and customary international law can be seen in the North Sea continental shelf case. When the convention defined the rights of archipelagic states, we finally could be able to predict with certainty which countries would be affected. Unlike municipal law, which applied to large populations, international law deals with a small number of states, around 200 countries. This makes it easier to predict how the laws will work. The small number of countries also makes it harder to separate the process of creating laws from enforcement. Part 11 of the convention, which deals with the deep seabed, was a major reason why many developed countries hesitated to ratify the convention. However, after the 1994 implementation agreement, which made significant changes to Part 11, most of these countries become parties to the convention. If there had been a separate system for non-member states in the deep seabed area, it could have conflicted with the broader goals of the convention. It seems that reconciling these 2 systems helped lead to the 1994 agreement. Finally, speaking of the deep seabed, Article 136 of the Convention stipulates that the deep seabed and its resources are the common heritage of mankind. With over 160 countries now part of the Convention, and after 30 years of implementation, can we now say that the legal status of the deep seabed has become part of customary international law? What about those countries that have consistently opposed Part 11? Are they persistent objectors? Does the persistent objection of certain states prevent it from meeting criteria for a peremptory norm of general international law? Or has it become a peremptory norm of general international law despite opposition from certain states? Thank you for your attention.
Thank you, President Kim, for your meaningful